but they still reserve the right to exercise them directly. Now, for the purposes of this appeal, I'll not talk about executive power or judicial authority in terms of powers envisaged under Article 1.1. I'll talk about legislative authority. So we are in agreement that indeed that power belongs to Wanjiku, the people. So is there a place in the Constitution where the Constitution envisages that Wanjiku will exercise legislative power directly? That is the question. And before I move to that, to the answer to that question,
and as you do so,
yes, Your Lordship.
Can you attempt to define the people? Are you included in the people?
Indeed, my Lord, I am the people. We are the people.
Am I included in the people?
You are.
So what is your definition of the people?
The people is, in fact, the Constitution does not talk about the people. It talks about the people of Kenya.
Yes.
Right? So if we are in Kenya, citizens of Kenya, living in Kenya, we are the people. But then, my Lord, when we the people collectively donate our powers to you individually to exercise on our behalf, you cease to be the people. So that now you're exercising powers on our behalf. So you cannot, unless you relinquish that power that we've given unto you, then you come back to our fold and now you remain as the people. So we give you authority as the judiciary. We give you authority as the legislature. We give you authority as the executive. So you cease at that moment being just the people, but we elevate you above the people. That is what. So there is a moral higher ground for the person to whom authority is donated.
When I speak about an issue that affects me as an individual and not as a judge.
Indeed, my Lord, and we have seen that happen time and again, that once you leave the bench and you walk home, you do not walk home as a judge. You do not exercise your powers as a judicial officer to your employees, to your neighbors. You remain an individual. So you will have to tell us, and let me just give an analogy, my Lord. The government and the people are gracious enough to facilitate the movements of the people we donate power to. Government vehicles. When you're on official duty, there is a flag to your vehicle. When you're not, I have seen judicial officers covering that part, symbolizing that now, this is not me the judge, this is me the person. So you must somehow put that crown down and now become the person. It must be known that the person speaking now is not the person to whom authority has been donated or not. That is my argument.
Thank you.
So, my Lord, then, as the Constitution envisaged that the people will exercise judicial authority, or rather legislative authority, the answer is yes. The people to whom legislative authority has been donated is the legislature, parliament, not the executive, not the judiciary. So the judiciary cannot purport to exercise legislative authority, neither can it purport to exercise executive authority, because that has not been donated to you. Neither can the executive purport to do that. And to answer the question that was posed by the bench, in a situation where the president feels he does not have the majority in parliament and feels somehow crippled, I would then suggest that is actually the essence of separation of power. Because the president is not in the business of legislating. That is the business of legislature. So he should not even be seen to bulldoze parliament, because that is not his business. So then, the people, how do they exercise legislative authority? Let's go to the preamble of our Constitution. And my president read that part, but there is another angle I want to bring into it. At the end, it says, we the people, having talked about a lot of things, exercising our sovereign and inalienable right to determine the form of governance to our country, and having participated fully in the making of this constitution. Participated fully. Not partially, not indirectly, but fully. There are two words that go after, my lords and my ladies. Adopt, then immediately enact. They do not just adopt, they adopt that which they have enacted. So the key word there, and I want you to take note of the arrangement, is adopt coming after enacting. So then, at the preamble, we are clear that we the people have legislative authority, and we can exercise that power directly by fully participating in the constitution making process. Let us jump to the elephant in the room, 255, and see what it says. It says, and I read, a proposed amendment to this constitution shall be enacted. The word again appears, enacted, in accordance with Article 256 and 257. And then what happens? Approved. The preamble talks about adopting after enacting. 255 talks about enacting, then approving by way of a referendum. So let's not confuse the two terms. You enact, you adopt, you approve. Rather, you approve, then you adopt. That is the sequence. That is found, again, under 255(3), that an amendment to this constitution that does not relate to a matter specified in clause 1, again, shall be enacted, not approved, not adopted, but enacted. So the instructive word is enact. Either by Parliament and Article 256, or by the people and Parliament in accordance with Article 257. So who should be involved in the process of enacting the Constitution? For the purposes of Article 255b, it is the people, in exercise of their legislative powers directly, without involving any other person, without donating. They have receded their authority given to the legislature, and they are exercising that directly. So it is enactment, then approval by way of a referendum. What the appellants have been telling us is that our role as the people is only to be seen at the approval stage. That is the referendum. So then the question is, who has enacted this law? And 257 is the only instance in this whole constitution where the people have reserved the right to enact, to legislate. There is no other. So could it then be said that under Article 1, that authority was pronounced in vain, that we have legislative power but in vain? We must be seen to exercise that authority at this juncture, 257. Let me go to Article 257, and again there has been a misunderstanding of 257 in my own understanding, that the initiative begins with their million signatures. A term is different. The term that is used there is very different. an amendment to this constitution may be proposed, not enacted, but proposed by a popular initiative signed by at least 1 million registered voters. So what they are proposing here is making it formal, what they have already enacted, what they have already created under the sovereign power. Because even in Parliament, a bill is presented for reading, a bill that has already been enacted by Parliament. Then it is read. A proposal is put on the table. So the 1 million signatures is not for the purposes of creating, it is for the purposes of officiating a process that they have already begun as the people. So when then the appellants come here and tell you that it doesn't matter where those proposals come from, that you only need to gather 1 million signatures and present, they are dead wrong. They must be told that. We submit that a popular initiative must begin with the people by way of enacting, then officiated by way of proposing, or rather endorsing, by 1 million signatures.
Who will do the enacting?
The people, my lord.
Tell us the methodology.
And that is why basic structure comes in. That you must have involved the people as per the preamble, fully participating in the process of enacting that document.
Mr. Mutuma, I'm not saying you are wrong. I want to understand, minus the legislature, without the legislature, how will the people enact?
Indeed, my lord. And that is why, under 256(4), it says that what can be presented to IBC could be in form of general suggestions, then converted into a bill. The people are powerful. The people are capable of drafting. In fact, if we were to go by the assertions of the appellants, this was drafted by Dennis Waweru and Junet Mohammed, the two of them. That's what they want us to agree. So that it should not be a problem for us to enact a law. In any case, this was done by 2 individuals. That is what they're telling us. So we have the capability.
Mr. Mutuma, I don't think we were told Junet Mohammed and Waweru enacted, but that they were the promoters.
I agree, but we have not been told who the enactors are. And that is even our greater problem. And that's why subsequently we will show that the executive was involved all through. So, but my point is this. It will not be difficult for the people to enact. Because we the people are lawyers. We the people are judges. We the people are drafters of the Constitution. As long as they are fully involved in the process, because that is it, enacting.
Did the legislature play any part in the birthing of this Constitution?
The current one, yes, my lord. But in a popular initiative, their role is merely ceremonial. They do not in any way involve. But there is a point I'm trying to make here, that at that juncture of enacting, it must be seen to be a process by the people.
All right,
and I do not doubt the people's capabilities of drafting a bill.
Move on, Council.
Yes. So my lord, then, it is not in doubt that a popular initiative can only be enacted by the people, proposed to IBC by the people, and approved finally at the referendum by the people.
Mr. Mutuma, I think you need to get that sequence right. According to you, the sequence is enactment, followed by proposal, followed by?
By approval. And approval is in 3 stages. At the county assemblies, there is a threshold. At the National Assembly, at the Senate, then finally at the ballot by the people. Those are the instances.
Isn't enacted really an all-encompassing term that refers to that entire process, from the moment there was a proposal, preparation of a bill, approval, so that in the end, when it's done, you can say it has been enacted. But if you say that you begin with enactment, then a proposal, what form does enactment take?
According to the definition of an enactment, again, I'll go back to the Black's Law Dictionary, the same definition, is to make law, to pass law.
Exactly, and
yes.
it is not enacted until it has come into being. But in your sequencing, you say it is enactment followed by proposal and approval, and that is getting me a bit confused.
A proper reading, my lord, of Article 255 talks about those two processes: enactment and then approval. So it cannot then be that enactment is the final product when the Constitution talks about enactment by Parliament and approval by way of a referendum. So there is a distinction right from 255 that you enact, then you send that which you have enacted for approval by way of a referendum.
But if it is in accordance with 256, and 256 talks of a bill, are you saying surely the legislature is not the one that is going to formulate this bill?
My lord,
because 255 says in accordance with 256. And 256 says a bill to amend this constitution may be introduced in either house of parliament.
Yes, under 256, my lord, Parliament has the right to enact.
No, I'm saying
yes.
255 reads, a proposed amendment to this constitution shall be enacted in accordance with Article 256 or 257. And 256 talks of a bill to amend this constitution may be introduced in either house of parliament.
My understanding, my lord, of the role of Parliament at 255 3b is that at the end of it all, we will see Parliament either approving, then it becomes the final product, if it does not involve the protected clauses under 255, then they will now enact and approve at that juncture.
All right.
Yes.
Please move on.
Thank you.
Before you move on, now, since your stand is you are faulting the process, and that is why we are all engaged here. Just for for me to understand, for me to understand you better and move on the same wavelength, in a minute or in a second, according to you, and you are going to explain to us what should have been the corrective procedure in line with the definitions that you have given us, just for me to understand so that we move together.
What I was trying to establish, because that was the appellant's case, is that it does not matter where the promoter of the popular initiative gets the proposals from. That was my argument. My argument is that a promoter from nowhere does not become the initiator of a popular initiative merely because they have brought 1 million signatures. So they must be able to establish that the people have been involved fully in that process. And now I am moving to my second and last part. I see I only have 29 minutes. My Lord, then, with that understanding in mind, who then initiated this process? Because we have seen the executive cannot initiate because they have not been given legislative authority. That has not been donated to them. Parliament has also not been given authority to legislate under 257. Theirs has been reserved under 256. Then, where did we get this impugned constitutional amendment from? My Lord, the appellants have come before this court. They have advanced 3 theories, and I call them theories because they come from different appellants. The first theory is that this was an initiative by one Dennis Waweru and Junet Mohammed. That has been submitted. Now I find that to be, for lack of better terms, taking us for a ride. So instead of them coming here and owning up, coming out clear to tell us who the promoter and initiator was, they have told us these 2 individuals promoted this initiative. The second theory is that it is not Dennis Waweru and Junet Mohammed in their personal capacity, but an entity known as BBI National Secretariat. The other theory that has been brought to your attention is that it could be, and I'm using the word very carefully, because that came out, though not very expressly, that's why I'm calling it a theory. It could be the president, either in his official capacity as a symbol of national unity under Article 130, 131, and there is nothing prevented him from actually initiating a popular initiative, or on the other hand, it is the president, but not in his official capacity, but as a person who also enjoys rights under the Constitution. My lords and my ladies, the impugned amendment process must be viewed as a direct product of the handshake that we all know about. Those facts are not in dispute. At the steps of Harambee House, between His Excellency the President in his official capacity and Right Honorable Raila Amolo Odinga. We submit that though the handshake was packaged as an initiative to promote national unity, cohesion, fostering cohesion and bringing about unity, it was a Trojan horse. A Trojan horse packaged as a unity package by the state to use executive powers to amend the Constitution. And let me pause there and address an issue that I know I might forget to. When the handshake happened, my client, Third Alliance, proceeded to the High Court and filed petition 451 of 2018. You have been told that you declare the petitions in the High Court res judicata on account of that petition 451 of 2018. Now, after the handshake, my clients were apprehensive that this is actually a Trojan horse, and they moved to the High Court and sought for declarations to declare the establishment of the task force as illegal. We filed that matter in 2018. The declarations we sought were only to declare the establishment of the BBI task force as unconstitutionally constituted and disregard its report. At the time, suffice to note that we do not have the BBI steering committee. Justice Mativo looked at the terms of reference of the task force and found nothing wrong with the terms of reference, and that the president was within his powers under Article 130, 131 to foster national unity and establish a task force, but only to the extent that it was going to advise him on policy issues. You will note from that Gazette notice that there is nothing mentioning amendment of a constitution. So we agreed with Justice Mativo 100%. That's why we never appealed. So to say that this matter is res judicata is not correct. The parties were different. The principal party there was the Building Bridges Task Force. It is not a party in these proceedings. The issues were different. It did not touch on the amendment of the Constitution. So it cannot be said that it is res judicata. Now, was it Dennis Waweru that initiated this process? In our petition that we filed in the High Court, we made a description of the parties that we sued. Because the first party that we sued was the Building Bridges Steering Committee that had been established by way of a Gazette notice dated 10th of January 2020. Now, we also sued the BBI National Secretariat, and this is how we defined them. The first respondent, and I'm looking at pages 1477 of the AG's Record of Appeal, Volume 4, that the petitioners, that the first respondent is the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force established by the President of the Republic of Kenya by way of a Gazette notice dated 10th of January 2020. The second respondent in our petition was the BBI National Secretariat, which we defined as follows: as an administrative department of the first respondent. The said secretariat, in our own description, is co-chaired by the following individuals. One, Honorable Junet Mohammed, who is a member of National Assembly under the ODM ticket, and Honorable Dennis Waweru of the Jubilee Party. That is how we describe them. Now, after being sued and served, the first and second respondents instructed an advocate, Messrs. Paul Mwangi and Company Advocates, via a notice of appointment dated 10th of December 2020. It's to be found at page 1741 of the Attorney General's response, Records of Appeal, Volume 5. He entered appearance for the respondents, who is the BBI Steering Committee and the Secretariat, not Junet Mohammed, not Dennis Waweru. Now, according to the submissions filed by the appellants at page 37, this is the BBI's submissions. They fault the High Court for making the following orders: that it is evident from paragraph 529 of the impugned judgment, the learned judges fundamentally conflated the roles of the task force and the steering committee on the one hand with that of Honorable Junet Mohammed and Dennis Waweru. This is very important. Trading in the name and style of BBI National Secretariat. So what they are telling us is that BBI National Secretariat is a business entity owned by Junet Mohammed and Dennis Waweru. That is in their submissions. let us contradict what they said in their response in the High Court. They filed a response to our petition. That replying affidavit is to be found at pages 1755, again, of volume 5 of the AG's Records of Appeal. This is very interesting, my lords. Dennis Waweru swears an affidavit dated February 5th. At paragraph 1, he says, I am the co-chairperson of the Building Bridges to a United Kenya National Secretariat, and my co-chairperson being the Honorable Mohammed Junet, together with Honorable Junet Mohammed, duly authorized to swear this affidavit on behalf of my co-chairperson and on behalf of BBI, Honorable Raila Amolo, in this case. My point is, the respondent in that case was not Junet Mohammed, was not Dennis Waweru. We sued them in their capacity as officials of national, or rather BBI National Secretariat. They never filed a single notice of protest to that description. They in fact confirmed our position by way of an affidavit that they are co-chairperson of that entity. At paragraph 3, they say, describing now the respondents, rather the BBI initiative, that the Building Bridges to a United Kenya was created and mandated with the task of initiating constitutional amendment process and unifying Kenyans, among other functions. They confirm it in their own pleadings.
So what is your bottom line, counsel?
My bottom line,
following that argument.
My bottom line,
yes,
my lord,
yes,
is that Dennis Waweru, Junet Mohammed cannot be said at this juncture to be the initiators of this process. It must be seen as an initiation of the friend, Senior Counsel Otiende Amolo, saying that as at 30th of June 2020, the BBI steering committee was not in existence. That is what they said. It is also captured in their submissions. As of 16th of October 2020, months after 30th of June 2020, when it is said that the BBI task force was not in existence, that is when the BBI steering committee was handing over the report to the president at Kisii State Lodge. We annexed that in our affidavits. In their forward, dated 16th October 2020, they say that, and it is addressed to Your Excellency the President of the Republic of Kenya, that you appointed this steering committee by Gazette notice published on 30th January 2020, and they state the terms of reference. I do not want to rehash them. But at the end, what do they present to the president on 16th of October 2020, when apparently they were not in existence in accordance to the appellant's case? The result is the following: 1, policy; 2, administrative; 3, statutory and constitutional instruments that address the national challenges outlined in the joint communique of the Building Bridges Initiative. It is in this report where the impugned, and that is now the gist of this case, it is in this committee, this report rather, where the impugned BBI, that is the Constitutional Amendment Bill of 2020, was attached to that report. That evidence again was produced. I invite you to look at the affidavit of Mirodu Waweru, sworn on 3rd of December 2020. That report is signed by all the members, in the next page, of the steering committee appointed by the president, including my good friend, Mr. Paul Mwangi. His signature is here as a joint secretary. So they are the people who drafted, that's my point, who enacted this piece of legislation, using executive authority by way of a gazette notice. That is the point that I was interested in making. In fact, looking at the bill itself, it does not in any way mention the so-called promoters. At volume 7 of the AG's record of appeal at page 2534, that bill, the Constitution of Kenya Amendment Bill 2020, dated 25th November 2020, was number 1, most importantly, printed by the government printer. At the end of it all, it is said the promoters at the end, to be found at page 2576, are the following: Building Bridges Initiative, stroke promoter. It is there in that bill. So when then the appellants come here, tell us what they did not tell the High Court, that they were indeed it was promoted by Dennis Wawere and Junet Mohammed, it is an outright lie. It cannot be allowed to pass. Parties are bound by their own pleadings. My lords, having established that indeed it was the executive that initiated this process, and having also established that the executive is not allowed to initiate a popular initiative because that power has not been donated to them, I submit that the impugned bill is unconstitutional. It is not a popular initiative. It is a presidential initiative. And to go back to the question that Your Lordship, the President of the Court of Appeal, asked me, whether once we donate once we donate sovereign power to you, do you still have individual rights? Like the President would want us to agree rather, yes. And like I said, you must avoid declothe yourself of executive authority, then become a citizen. I'll give you an example that happened with this same executive, Your Lordship. In 2014, our president was facing a personal case at The Hague. When he was leaving for that case, which was his personal matter to attend to, he did the right thing. And I believe, under the advice of Emeritus, AG then, Professor Githu Muigai, he handed over power to the Deputy President, appointed him as the acting president, went to The Hague as a citizen, was not received by the state there as a president, but as an individual. So if the president then wants to initiate such a process as a citizen, he must of all do exactly that. Announce to us that this is not the president doing this, it is me as a citizen. I see my time is running out. I have my colleagues to submit on a few issues. I submit that the appeals before you are not merited. The same should be dismissed. The court ought to uphold the judgment of the Superior Court. I'll invite my learned friend, Carol Gerono, to just address on a few issues. Thank you, my lord.
Thank you, Mr. Mutuma. Please introduce yourself, and I hope you know you have like 10 minutes, because we'll adjourn at 1:30.
My lord, we had, my name is Miss Caroline Gerono. I appear alongside Mr. Mutuma and Professor Kindiki for the 19th, 20th, and 21st respondents.
With your permission, my Lord, could I seek a clarification? This court gave directives earlier on that each of the respondents will have 2 hours, and put a caveat that there should be no repetition. My Lord and ladies, this matter is so monumental. I want to plead with you, even as my colleague finishes her time, that you allow us to do our 2 hours. There will be 0 repetition, and I believe will be of help to the court. And so, my Lord, I did a directive so that you can guide us as we go for lunch.
Are you talking of, Professor Kindiki, you talking of 2 hours over and above what has been taken by your other 2 colleagues?
No, my Lord, 2 hours cumulatively. I know we will be spending 1 hour by the time we go on recess, on adjournment. So I'm kindly requesting with tremendous humility if we could have the extra 1 hour after lunch.
1 more hour?
Yes, my Lord.
Ms. Cherono,
Yes, my Lord.
would you, in the remaining 9 minutes, have finished your bit?
No, my Lord. We had apportioned ourselves that I would do 30 minutes. So I would suggest to the court if we would adjourn for lunch, then we have 1 hour uninterrupted shared between me and between Professor Kindiki and myself.
Can we give Caroline Cherono like 15 minutes and Professor Kindiki 30 minutes, a total of 45 minutes? We can adjourn now so that you are able to, put your thoughts better. We'll try to accommodate with the request that you've made.
Sorry to come back on this, my Lord, but the appellants each had 2 uninterrupted hours, and they will also have a bite at the cherry because of the right to reply. It is only fair, my Lord, that you consider giving us, as a team, 2 hours, and how we share it, we can leave it to the internal mechanism.
Okay, then let us do this. Let us adjourn now, and when we come back, we will see what happens. We hear what you've said, Council. After 1 hour precisely. Council and his team. What happened? Put on the microphone.
My Lord, Professor is taking a bathroom break. He'll be with us in
Sorry, we can't hear you, Council.
My Lords, my name is Miss Muigai. I hold brief for Professor Gilly Muigai.
Yes.
He is having a short bathroom break. He'll be here in 10 minutes.
He's having a?
He's taking a call, an urgent call. He'll be here in 10 minutes.
5-10 minutes. Our health break is 30 minutes and put on the microphone, please.
I have been requested by Mr. Gatonye
Yes.
to inform the court that he'll be here in the next 10 minutes.
Council, we really don't want to hear that because unless we manage time, it will not be possible for us to finish these proceedings by Friday. The next 10 minutes, and it's now almost quarter to 11. So neither the counsel for IBC or the fourth appellant are ready to proceed. I thought there are many. What did you do? It is very unfortunate that we have to rise and come back at 11, but it will be at the expense of the appellants because they have.
Yes.
We are just about to rise at the expense. Yes.
My name is Elisha. So that we can get this direction as soon as you come back. I just sought to know whether the court could direct that the respondents who support the appeals will argue their case together with the appellants.
Yes, thank you very much. Thank you for that because I had actually sought directions.
Thank you, my
Lord. And I got to understand that the seventh respondent, the eighth respondent, the 43rd, 45th respondent, among others, are supporting the appellant's appeal.
Correct. So I just wanted the direction to them.
Yes, thank you very much.
Thank you,
and therefore, what we will do with them, we will not give them the time they have requested for because I think all the issues, the most important issues have already been covered. We'll give them, I think, a maximum of 30 minutes to highlight any additional issue.
Much obliged.
Yes.
My Lord President, members of the court, I want first to start by apologizing unreservedly for the delay. I take full and unconditional responsibility for the conduct of my team, and I hope you will find it in your hearts to forgive us for that misconduct.
We will forgive you, but the penalty is that the 5-10 minutes that we have spent here will be knocked off your time.
Okay, my Lord, I will, as we go along, I will seek to persuade you. My Lords, My Lords, as I indicated yesterday, I am instructed by Mr. Eric Gumbo, Esquire, Counsel for IEBC, to lead the appeal by the IEBC before this Honorable Court, that being Civil Appeal number 291 of 221, as consolidated with E292, E293, and E294. I have already introduced my team, so I do not want to take time doing that. But I do wish, my Lords, to draw your attention to the documents we rely on.
Sorry, before you do that, Senior Counsel, can we have an indication? I think, will you require the 2 hours like the other appellant? I thought, looking at the nature of grounds raised in your appeal, but that is the IEBC.
Yes, my Lord.
Can we give you like 1 hour, maximum 1.5 hours?
My Lord, let us suggest that we keep the 2 hours, but we will not insist on using them. If we exhaust them, especially if we note that you are no longer writing because you have been persuaded, we will be happy to let go of the two. If that is a happy compromise, my Lord.
Well, the fact that we are not writing is not an indicator that we've been persuaded, because as we said, these proceedings are being recorded,
yeah,
and it has reduced the burden of writing. But Senior Counsel, please proceed.
Yeah, okay, my Lord, we have heard the sentiment of the court. We will work around that.
All right.
We have a memorandum and record of appeal dated the 31st of May 2021. It will be found at pages 9 to 21. We have written submissions and a list of digest of cases that is filed on the 9th of June 2021. We have a replying affidavit by one Michael Gore, pursuant to leave granted via a ruling of the 25th of June 2021, and which we filed on the 28th of June 2021. We have a supplementary list of authorities filed on the 28th of June 2021. Now, my Lords, let me start by saying what may appear to be the obvious. We are aggrieved, and we have come before this court because we believe that in its judgment, the court below failed to appreciate some very fundamental constitutional and legal tenets. The first one is that the IEBC is an independent constitutional commission, and that it enjoys the same constitutional protection as indeed does this honorable court. In fact, my Lords, if you look at Article 249, sub-Article 2B of the Constitution, it is made absolutely clear that the Commission is not under the direction or control of any other body or authority. And it is our view that in the exercise of the mandate donated by law, that is to conduct and supervise referenda and elections, the IEBC ought not to be under the direction of any other body or authority. We have filed an appeal that raises 12 grounds. We have reduced these 12 grounds into 4 main thematic areas as follows. The finding as to the quorum of the Commission during the conduct of the work that is now impugned, and I will be arguing that point. The second one is the interpretation of the role of the appellant in relation to the process of amendment of the Constitution through popular initiative. That is grounds 2, 3, 7, 8, and 9, and that will be argued by my learned friend, Mr. Eric Gumbo. The third one is the place of administrative measures and processes guiding the performance of the appellant's mandate. That's grounds 4, 5, and 6, and that will be argued by my learned friend, Mr. Moses Kipkogei. And finally, I will argue the point of the proper jurisdiction of the High Court under Article 156(3), and then we will finish. Now, let me start with the quorum. It is our submission that the learned judges of the Superior Court add in law and indeed in fact in their finding that the appellant lacked the requisite quorum for the performance of its mandate. We say that for two reasons. Reason number one, the impugned finding is premised on a non-existent law. I will demonstrate to you that the law that the court purported to rely on to find that there was no quorum was no longer law because it had been declared to be unconstitutional by a court of competent jurisdiction. Secondly, my lords, the impugned findings ran foul of a subsisting decision in rem of a competent constitutional court. Let me go to the first one. Why do we say that there was no existing law? My lords, if you look at the findings of the Superior Court, and they are to be found in paragraphs 702, 714, and 719 of the judgment, and I think this is at pages 730, 71, 37, 71, 40, and 71, 42 of the record. It is apparent from a reading of those findings that the Superior Court premised its determination in respect of the appellant's quorum on the single ground that the provisions of paragraph 5 and 7 of the second schedule of the IBC Act were in force. As a matter of fact, they were not in force. Why were they not in force? They were not in force because in the case of Katiba Institute and another versus the Attorney General and another, Constitutional Petition number 548 of 2017, this is at page 238 of our authorities.
Page?
238.
Okay.
Mwita J, and it is important to mention the name of the judge, Mwita J had declared these provisions to be unconstitutional. That is important because Mwita J was serving as a judge in the constitutional division of the High Court. As if that is not enough, my lords, the decision by Mwita J remained the ruling jurisprudence on this point for 37 months up to the time the matter now before you was brought to the Superior Court. During that whole time, there was never an appeal from the decision of Mwita J. And to the best of our ability, there has been no appeal. Now, the important question of law that arises is this: what is the effect of a declaration of unconstitutionality? What happens to the statute that a court of competent jurisdiction finds to be unconstitutional? The judges in the Superior Court seemed to suggest that what should happen is that you should revert to the status quo ante. It is our very humble view that there is no jurisprudence supporting such a position. Parliament first repeals, then enacts. So if Parliament repeals, then enacts, if a judge strikes down the repealed provision, there is no reenactment. It now means that that provision relating to quorum no longer exists. In our submissions, my Lord, we have made that argument at great length. I don't want to go into it. I have demonstrated that when a judge strikes out provisions as unconstitutional, there are only three ways that the law can be interpreted. One is that there is a prospective overruling, meaning from midnight to night, this becomes the new law, or there can be a declaration that the striking out takes effect from the date of the filing of the petition or the suit, or three, that a declaration that the striking out is to be deemed to have struck out the statute from the date it took effect. There are numerous authorities of the Supreme Court. I have referred to them: Meru Wambui versus Gishu Kingara, Supreme Court petition number 7 of 2013. My lords will find it at paragraph 69, paragraph 69 and 70 of the bundle of the authorities. And the pertinent paragraph is at 84 to 89 of the judgment. The Supreme Court stated the law generally that although a judgment may be silent on the effects of its declaration of unconstitutionality, thereby invalidating any action in respect or emanating from the unconstitutional provision, the court still retained the right in appropriate cases to exercise its jurisdiction and give its constitutional interpretation retrospectively or prospectively. Now, where you have retrospective effect, the court in Meru Wambui quoted with approval the South African case of C.S. Moise versus the Transitional Local Council of Greater Jamestown. It dealt also with the case of the governor of Bow Hill Prison. This is at page 70 and 71 of our bundle, and I don't want to waste your time regurgitating the particular circumstances and the finding. But I just want to make this point one more time, that the court confirms that a statute that has been struck out, or portions of the statute that can have been struck out, cannot be deemed to have been revived under any method known to our law. So to the extent that their lordship said, we have a quorum problem because they are not complying with Section 5 and Section 7 of the second schedule, the court was saying we are not complying with a dead law, a law that no longer existed. And that's why we associate ourselves with the learned submissions of Otiende Amolo and Kamau Karori. What was the default membership provision? The default membership provision was as provided in Article 250, sub-Article 1 of the Constitution, 3 members. Now, had the learned judges of the Superior Court found that IEBC has 2 members, they would have been right to say this is not a constitutional creature known to the law of the Republic of Kenya. Had they found that IEBC has 11 commissioners. Similarly, they would have said this one violates Article 250, sub-Article 1 of the Constitution. In this case, IEBC was in very good protection of the law, as we have said, because it met the provisions of Article 250, sub-Article 1. What is my second limb on this issue of quorum? I come back to the question of the decision of the court. Okwene J had been confronted directly with this question. In the case of Isaiah B. Watt versus IEBC and another, Nairobi High Court petition number 212 of 2018, which is authority number 10 in our list, and you will find it at page 240 of our bundle of documents. Two significant issues were before Okwene J. And I would like my lords to look at paragraph 27 of the judgment, her judgment, which is at page 245 of the bundle of the authorities. This is what the gracious judge said. She held that the IEBC Act contemplated that vacancies would arise. Therefore, the mere fact that there was a vacancy did not render the commission unconstitutional. My lords, I want to stop there and draw your attention to Article Section 7, subsection 3 of the IEBC Act. Because this is the saving provision. It is in the statute of virtually every commission and the articles and memoranda of almost every company. And it states that notwithstanding the existence of a vacancy, in the composition of the commission nonetheless was deemed to be validly composed for purposes of considering its work. The second point that the learned lady judge made, which is very material, is at paragraph 46 of her judgment, which is at page 249 of the bundle of the authorities. She found that the conduct of elections or by-elections is not a matter that arises out of resolutions or decisions of commissioners at meetings of the commission, but are dictated by the operation of law. So it doesn't matter whether you have 5 or 4 or 3, or the work of the commission must continue because the law itself recognizes that the existence of a vacancy is not sufficient. So we submit, my lords.
Senior counsel, would you know whether this bench, the attention of the bench was drawn to that decision by Okwene J?
Yes. I don't want to use strong language, but the bench ignored several authorities that were brought to their attention on the very specific cases that they were dealing with. And I want to add...
Professor, with regard to this particular decision by Justice Okwene, did the learned judges ignore, or did they say that we have seen it, but we are not bound by it?
Well, that's what I'm going to demonstrate in a short time, that indeed they said what my Lord says they did, but I am saying it was not open to them to do that. And I am saying we can create judicial anarchy if courts of law make decisions in rem on matters of public law, and courts of equal jurisdiction, where this is brought to them, ignore that and say, I have a different opinion. In the meantime, this decision in rem has begun to change the manner in which the constitutional institutions operate. And my learned friend, Mr. Gumbo, will be drawing attention to the court to a similar matter taken before Ochenje in Kisumu. And Ochenje say, I cannot possibly interrupt this sort of process because the possibility that every court in every part of Kenya could be weighing in on this would create judicial mayhem. We must have a structured way of doing this. The structured way is to allow an appellate process to take place. Now we submit, my Lord, that the effect of the Biwott decision is that there was an authoritative pronouncement by a court of competent jurisdiction as to the appellant's quorum. And the appellant had then proceeded to conduct its business on the basis of that finding by the learned judge. We submit that a declaration by a superior court on an issue in rem alters the status of the subject matter of the declaration. Therefore, such declarations can only be reversed by a court exercising appellate jurisdiction. And I know it is the tradition of this court, and I have been before many, many courts in which the judge says, my learned brother, my learned sister has pronounced himself on this point. I do not think it would be fair for me to try and give a different meaning to this statute, and therefore we should await an appellate process. So we do argue, my lords, that there is, in a sense, a matter of issue estoppel that was brushed aside by the court. The court brushed it aside without giving some context to what this would mean in practice. There are two cases that I don't want to go into because we don't have the time. The Supreme Court of Canada in the same of Radal versus Saskatchewan. It is at page 156 to 157 of our bundle, and it deals with this issue. The court in Ames versus the Queen, page 172 of our bundle. We conclude our submission by reiterating that a declaration made by a court of competent jurisdiction in rem in a public law proceeding remains an authoritative pronouncement on the state of the law and can only be upset on appeal. And let me say this, my lords, with your permission. We have become used these days to saying it was a 3-judge bench, it was a 5-judge bench, it was a 7-judge bench. With tremendous respect, nothing in our jurisprudence turns on the number of judges. We do it out of abundant caution, out of demonstrating how important, how significant a matter is. But the jurisprudence of a single judge is as important as the jurisprudence of a 5-bench. And they cannot therefore have been saying, we are 5, we have overruled you. Let me come to my last presentation so that I may give way to my colleagues to argue the other point. What is the jurisdiction of the High Court of Kenya under Article 1563? What is the jurisdiction of the High Court of Kenya under Article 153? I have submitted before, and I'm happy to submit it again, that there seems this our very well-regarded constitution, and I must say a bit of my life was put into it over 5 years. And it is praised for many things all over the world. Transformative, radical, and so on and so forth. This Constitution of Kenya 2010 does not rewrite the foundations of the law of Kenya, which remain as they have been since 1897. No court in Kenya has any jurisdiction to hear any grievance except a legal grievance. That was always the law, and it is the law after 2010. And therefore, to my mind, every dispute coming before the law must be anchored on the Constitution and on the law. Regrettably, a trend has taken root where all political, social, and economic grievances are given a very thin layer of law and taken before the court. And this has created a situation where, in my very humble view, the court is increasingly called upon to intervene in areas that it neither has the capacity nor the time, and which erodes the dignity of the court, because when the orders finally come out, they do not have the sanctity and certainty of judicial directions by the way of orders in the traditional sense. The High Court of Kenya, sitting as a constitutional court, has a limited jurisdiction. I know that is not a popular view, but it is the correct view in law, in my humble submission. The High Court of Kenya, sitting as a constitutional court, has a limited view. And that view is to entertain constitutional controversies brought to it by parties who have standing before the court and where a clear course of action exists. There is nothing in the Constitution of Kenya 2010 that said you can come to court if you have no nexus with the dispute, if you have no standing, if there is no course of action. You can write a big petition, throw it to the court and say, please help us because we are very annoyed with the action of the chief. That is not the law of Kenya. What then is the law of Kenya? If you look at what the judges in the Superior Court did, 9 out of 10 of what constitutes their order is an opinion. It is an advisory opinion. They say, we have reviewed as scholars and jurists and thinkers about the law, and we find this basic doctrine theory applies to Kenya. Who has that controversy? Who has that controversy? There isn't a controversy. There is an invitation by the petitioners for the High Court to sit as a philosophical tribunal and interrogate philosophical ideas and then declare whether they apply to Kenya. That is not... Yes.
Wasn't there a claim that there was a threat of violation of the Constitution?
There was a threat, sir, of a...
One of the petitions based on the perceived a threat or violation of the Constitution? Did that give them footing?
No, no, sir. No, my lord. It cannot give them footing, because I think it is right for the High Court to say, we are squatters in Uhuru Park, but we've been here for 20 years. The government wants to build the office of the Attorney General inside the park. We apprehend that we will be removed without any measures being taken to protect us and our children. Give us an order to stop that being done until a transitional process is done. If I were a judge, I would issue an order. That is a concrete dispute between concrete parties about a concrete property. Here, these very learned applicants are merely inviting the court that, please, let us engage in a debating, let us have a debating session in the High Court, convert the court into a philosophical forum, and then we ask ourselves, what is the basic doctrine question? Does it apply in Kenya? Has it applied in other countries? Has it been rejected in others? So at the end of the day, should it apply to Kenya? Nobody of them is touching on the Constitution. Nobody is saying sections, nobody. So at the end of the day...
Professor, is that entirely correct? The question is coming from here.
Correct me, my lord.
Is that entirely correct? If you look at the petition that were before the court, were they not saying that here is a process that is happening, and this process is violative of certain premises of the Constitution, and that if this process goes to its final conclusion, it is going to alter fundamentally the essence of the Constitution that was agreed on and passed in 2010, and that cannot happen because what then happened is not an amendment, but basically it amounts to a replacement of the Constitution. Are you entirely fair to the judges to say they just sat as a philosophical tribunal and dealt with matters all out there in the air without something concrete on the ground?
What I was trying to do, my lord, was to draw a distinction between where the court is trying to stop something that potentially may happen, and with it happening, there would be a violation of the Constitution. Here, we have a legislative process, a referendum process, that is inchoate. And it's like saying that the court has issued an order to the Speaker of Parliament. Let me remind you, my lord, when I was in the Guy Commission, we were writing the chapter on the judiciary. And the late Justice Moijo Kewa and a number of judges came to their own court, filed their own suit, and an order was given to them telling the commission that I was a member of not to discuss the chapter on the judiciary. Needless to say, that order was not capable of obedience. It was not capable of obedience, nor was it, in my very humble view, well-founded in law. It was a terrible case of judicial overreach, not to mention a terrible conflict of interest matter. In this matter, and I associate totally with my learned friend James Orengo, with whom I have not argued a matter on the same side for 20 years. So I am quite happy with this recent development. I am quite happy to associate with James Orengo's very, in my very humble view, very well thought out argument that a political process must be permitted to evolve politically. And a judicial intervention commends itself where that process is complete and a legal product exists to which the judges then say, this cannot be allowed to stand. Let me give you an example. One of the proposed changes is to bring in a judicial ombudsman. I personally don't know whether that is good or bad or whatever. But I can possibly see a day, if this referendum was successful, where somebody would come and say, I am attacking only that section, because as it reads now, it is inconsistent with that section, and it undermines that framework. That would be a jurisdiction that I personally would entertain and would say the judges are the best people to speak about that. So, to my very humble view, the judges exercised a jurisdiction that the people of Kenya reserved for the Supreme Court. Only the Supreme Court of Kenya can issue an advisory opinion. The High Court decided to give advisory opinions on hypothetical issues, coached in the language that it did. As a result, it trampled upon the independence of IEBC. And I want to repeat that, my Lord. Independence is not for the judiciary alone. Independence is for every constitutional institution. Parliament is independent, the president is independent, and all these commissions are independent. That is why the Auditor General is independent, and so on. One thing disturbed me in this matter, my Lord, which I may mention before I sit down. It is how the questions were framed. In the old days, my lords will remember, it was usual at the end, at the close of pleadings, for the judge or judges to invite the parties to frame the issues, so that the court would be answering the issues framed by the parties. I was a bit surprised that the issues were framed by the judges, and the manner in which they were framed seems to have tilted the case in a certain direction. And I think Paul Mwangi spoke to the question of how framing the issues in that way allowed the judges to cherry pick the history of the Constitution and the controversies of the Constitution. And I think that that was not proper. So I want to urge the court to find that this court had a lot of opportunity to exercise avoidance, which is not a dirty jurisprudential word. It is a prudential principle of judicial decision making, avoidance. The court had an opportunity to find that the issues, the grievances brought to it were not live, they were not ripe. And the doctrine of ripeness, you will be told, is from the old archaic jurisprudence of the common law. No, it is not. It is being used today by the best constitutional courts in the world, because you only have so much judicial time. You cannot convert yourself into a debating society. Above all else, therefore, my Lord, I say that this judgment cannot be allowed to stand. It violates so many fundamental tenets of good constitutional interpretation and management of constitutional conflict that if it were allowed to stand, it will be the recipe for chaos. As a student of these matters, at the end of reading this judgment, I came to one conclusion, that this judgment is saying the people of Kenya cannot be trusted with their own constitution which they made. And there are parts of it which nobody knows, which will never be amended up to eternity. Now, had we been told what they are, probably one can take comfort, one can sleep better. We were told there are parts of this constitution that you shall never, ever amend, because we can't trust you with them. Especially you politicians, and you, the advisor of politicians, and even the people themselves. Which are they? The court doesn't know. We don't know. The scholars here, amicus scholars, they don't know. It is a very dangerous proposition, and it only invites insurrection. Then people say, if we can't change the constitution, surely we must overthrow it. That is a terrible thought, should never be allowed to take root. Thank you. I'll ask my junior.
One last question, Prof. Was it the finding of the judges that certain clauses in the Constitution provisions were totally incapable of amendment, or did they say they were not capable of amendment through the constitutive process, but only through the constituent power? Because I've heard that said here, that the judges said cannot under any circumstances be amended or changed. Is that what the judges said?
Well, I understood them. I understood. My reading was that if you have an eternity clause, it means exactly that, until the end of time. But by the way, my lord, you helped me make another point.
Just a moment, please. The eternity clause as a term of art, first of all, is not new. Wasn't used by these judges for the first time. It's been used before, but it has been it has been explained as to what it means. That really, I mean, humanity is not eternal, so there can be no eternity out of the activities of finite beings. But that what it means really is that it's not amendable but by replacement. Isn't that what it means? As opposed to the end of time, or beyond time, because it's eternity?
My lord, you helped me make another point in answer to your question.
Yes.
In this judgment, all these terms are conflated as if they mean the same. Yeah, and it is very difficult for any jurist to understand at which point the judge uses eternity, in which way, at which he uses. For example, there is a very old method in constitutional law of making a distinction between entrenched provisions and non-entrenched provision. And it's a very old tradition, my lord knows this very well. In the 1963 Constitution, there were entrenched provision. And in fact, in 1964, in the First Amendment making us a republic, the little one tucked beneath the republic was to remove then the provision requiring referendum for entrenched provisions. And so from 63 until 2010, we were sailing without any entrenched provision. In Bomet, we brought back the entrenched provisions. That's why you cannot change the sovereignty of Kenya, the national anthem, several other things there, the independence of the judiciary, etc., etc., etc. Those are entrenched provisions. I don't know whether the judges think of those ones as basic structure, because to entrench is one thing, basic structure is an entirely other confusing doctrine. May I allow my assistant?
Before you do that, let me take you back to the Biwott case. What was the reason that the High Court gave for not following it? And why do you say it is a decision in rem?
Is my Lord asking what reason the court gave for allowing the commission to continue working?
No, for not following the decision.
No, let me, Mr. Gumbo will deal with that. May I ask Mr. Gumbo to deal with that? Okay. Thank you, my lords.
Good morning, my lords and my ladies. My name is Gumbo Eric. I will take this moment to address you on a number of issues, particularly arising under the second thematic area of the first appellant's written submissions. But before I get into that, perhaps I could start with the question that has been raised by my lord. My lord, when we say that those decisions are in rem, what we have in mind is, my lord, a decision issued in relation to a public law question does not apply to the parties who are before a court in that matter alone. If a constitutional interpretation is made this morning, my lords and my ladies, it shall apply to the matter that is before the court at that point in time, and it will also remain the law going forward until and unless changed by a different court. And that perhaps is the argument that we are making, that once that has been made, then really, for consistency and good order, we need to have the other courts.
The question is,
yes,
did the High Court justify why it was not following it?
My lord, in my understanding, there wasn't a proper justification in any of the matters that perhaps we are handling. There have been, in my reading of that judgment, indications in certain matters that perhaps arose in the course of the decision, where the judges say that I will not follow this. But when you get to the ultimate question that they answer, you find that they have themselves departed from the position they had taken initially. So that if you take, for example, or perhaps let me not get into that, if my lord, you're satisfied with that, so that I can just go into the submissions. Thank you very much, my lord.
Mr. Gumbo.
Yes, my lord.
You know, your answer to that question was that you think that generally there are many cases they did not consider and did not give a proper reason. But the thing that interests us, at least my brother and I, is what reason, what specific reasons did these judges give for not following Isaiah Biwott Kwangonyi? And surely it's there in the judgment. What reason was it?
My lords, and this is what I was explaining, at the beginning of that decision, the lordships give reasons. They say that the judge did not respond to a specific issue. Then what is of concern to us is that ultimately the finding is on the question of the quorum itself. In fact, when they make their final determination, it is on the question of quorum itself, which then is on all fours what Justice Okoye had made a finding on. And that is the position or the point that my learned senior counsel professor was making. Thank you very much, my lord.
Thank you, Mr. Gumbo. Actually, they gave quite some reasons from paragraph 7, 11 going forward, but it's okay, we'll find it for ourselves.
I'm also glad, my lord. My lord, with that, perhaps I could go to the substance of my submission this morning before you. I have four areas that I would want to tackle before you. One of them is in relation to the meaning that should be ascribed to the provisions of Article 257(4) in relation to the obligation of the Independent Electoral and Boundaries Commission. My lords and my ladies, in responding to that question, I'll take two approaches. I will look at the text of the Constitution, and I'll then look at the issue that my learned judge, Justice Kiagi, had raised, the manner in which the Independent Electoral and Boundaries Commission applied the question specifically on verification. My lords and my ladies, I will then look at the second question, which is the question around public participation, specifically whether Article 257(4) imposes an obligation on the IEBC to confirm that the promoters of an initiative have engaged in appropriate or satisfactory public participation. The third thing that I'll be looking at is the question of a nationwide registration of voters. In their judgment, the Lordship say that there's an obligation on the IEBC to ensure that there is nationwide registration of voters before a referendum can be then taken up. I'll be addressing that question. And finally, I'll then want to address you on the referendum question. My lords and my ladies, learned senior counsel had given the array of documents that we would seek to rely on, but for purposes of my presentation, there's one more document that I would want to probably just draw to the attention of the court, and perhaps we'll then, when we get there, look at it. That is the format that was used by the Independent Electoral and Boundaries Commission for purposes of receiving the signatures. That document is to be found at page 1100 and 1101 of volume 2 of the appellant's record of appeal. My lords and my ladies, let me start on the question of the role of the IEBC under Article 257(4). We are, my lords and my ladies, particularly concerned or aggrieved by paragraphs 733, 734 of the judgment of a superior court, specifically in relation to the finding that authentication, that the Commission was also obligated to authenticate the signatures of the promoters of the initiative. My lords and my ladies, Article 257 speaks in a very broad way from an end-to-end perspective to the popular initiative as a route of amendment of our Constitution. It places various specific actors on that pathway that is between the Articles 257(1) up to where it ends at 257(10). In relation to what I have before you, my lords and my ladies, I would want to go specifically to Article 257(4), which is where the Independent Electoral and Boundaries Commission is given obligations under this Constitution, and that perhaps is what I would spend a bit of time addressing you on this afternoon. I had said that I would want to start by looking at the text of the Constitution. Learned Senior Counsel, Senator James Baringo, yesterday told us, and we agree with that position, that the best way to interpret a constitution is first by looking at the text of that constitution. My lords and my ladies, Article 257(4), if I may read, reads, "The promoters of a popular initiative shall deliver the draft bill and the supporting signatures to the Independent Electoral and Boundaries Commission, which shall verify that the initiative is supported by at least 1 million registered voters." My lords and my ladies, there is a comma after the use of the word Electoral Boundaries Commission, comma, then there's a pronoun which. My lords and my ladies, that pronoun which can be replaced with the names of Electoral and Boundaries Commission, so that a proper reading of that second part of Article 257(4) would be that the Electoral and Boundaries Commission shall verify that the initiative is supported by at least 1 million registered voters. My lords and my ladies, of note in that particular part of the Constitution is the use of the word verify, the use of the word initiative. Initiative, my lords and my ladies, is used in the context of Article 257(1), which means the popular initiative. Then it proceeds to say, is supported by at least 1 million registered voters. My lords and my ladies, registered voters is then another important issue or phraseology that we need to understand in its proper context. Why do I say that? When they say, when the Constitution says registered voters, we must then take it in the totality of the legal framework that we have in Kenya. Because the word registered voters is actually a word or a phraseology that is defined specifically in our laws. So if we look at it in the English, common ordinary English sense, there is a risk that we may lose the meaning. While at that, I would also want to say that, again, reading that part, which shall verify that the initiative is supported. It is important to know from, or to note from as early as now, that we're saying, the Constitution says, we shall verify that the initiative, not the signatures. Verify that the initiative is supported by at least 1 million registered voters. I'll pause at that, my lords and my ladies, for one moment. Just ask myself, why is this obligation reposed in the IEBC? My lords and my ladies, to respond to that question, because if it is a question of, for instance, looking at verifying the signatures, perhaps we would have said that the best institution would be the DCI, because they are able to, they have sufficient capacity to be able to do a forensic analysis of our signatures and any other material that is available to them, handwritten. My lords and my ladies, the reason why, in our view, the Independent Electoral and Boundaries Commission is then given this obligation under the Constitution is because they are the custodian of the architecture of our electoral platform. Specifically, my lords and my ladies, they are the custodian of the register of voters. The register of voters, my lords and my ladies, plays a central role in the understanding of the meaning that should be ascribed to Article 257(4). In our view, then, the use of the phraseology registered voters resonates very well with the fact of the existence of the register with the IEBC. And I'll probably just take one step back, look back into the judgment, just find how the judges looked at that issue. At paragraphs 477 to 484, the learned judges of the Superior Court went into the history of how this specific article found its way into the Constitution. They went into a discussion running from the WACO draft all the way to the revised harmonized draft. The emphasis, and you'll get an opportunity to look at those paragraphs, the emphasis in running through all those drafts, and there was consistency, was on the fact of registered voters, not signatures. On this issue, my lords and my ladies, I think we read from the same script, even with the respondents. I will pick out one respondent. The 76th respondent, Morara Omoke, learned counsel, says at paragraph 51 of his submissions filed before this court that the drafters of a clause intended that it be invoked by citizen registered voters. I underline citizen registered voters. So even from the respondent's perspective, significance and emphasis must then be put on the registered voters. That said, my lords and my lady, I will end that part by saying that the obligation of the IEBC then would rightly be said or summed as being a threshold obligation, a threshold test in relation to Article 257(4) as to whether it meets the test that is provided or the requirement under Article 257(1) for purposes of initiating a popular, or rather amendment to the Constitution through a popular initiative. That said, my lords and my ladies, I would want to come to how, and this was an important issue that learned judge raised, how the IEBC then looked at and interpreted that article. My lords and my ladies, I would want to beg for a bit of patience in this part because it is an important part. It is interrelated with many other things. And so I would want to take you through a granular understanding so that we are then able to follow and eventually even then get to know why, my lords and my ladies, the court below, that is the learned judges of the Superior Court, missed the point.
Okay, yeah, so can you then go straight to telling us what you think, I mean, the way you fought the learned judges for interpreting Article 257.4?
Yes, my lord. Permit me, my lord, to just give you this architecture, then it will be very obvious and easy to answer that question. So, my lords and my ladies, in applying the infrastructure, that is the register of voters, we start from an important question that Justice Kiage raised as to what biometrics are. My lords and my ladies, Regulation 8 of the register...
That was not my question at all.
I think it was a unique identifier.
Yes, my lord. I will come to it and you realize that perhaps we're talking about the same thing. My lords and my ladies, Regulation 8 of the Registration of Voters Regulation 2012 says that the register of voters shall contain biometric data and the particulars set out in Form A in the schedule. My lords and my ladies, Section 2 of the Elections Act defines biometric to mean the unique identifiers or attributes including fingerprints, hand geometry, earlobe geometry, retina and iris patterns, voice waves, DNA, and signatures. It is a fairly broad definition. Now, permit me to look at, just so that I complete that part, that is how then to apply for registration. You are referred to this need to have the biometric data and details set out in Form A to the schedule. Again, this is law. My lords, Form A, I've had an opportunity to look at Form A, which again appears in the Registration of Voter Regulations. It sets out the alphanumeric details. These are the details that then would be able to relate the biometrics to a specific individual. My lords, these are details to do with where your constituency is, where your county is, where your ward is, where the registration center is, your surname, your other names, your identity card, your passport or identity or passport details, date, sex, residential address, email address, and disability, if any. My lords and my ladies, that form then gives a declaration that when you are presenting that information, and this is important, that you also declare that you are in possession of either the national identity card or passport bearing the numbers which you have indicated in the application. And secondly, that you also declare that the details that you've given are accurate to the best of your knowledge. My lords, armed with that information, how then does IEBC go into verifying that the initiative is supported by at least 1 million registered voters? Learned Senior Counsel, Mr. Otiende Amolo, did give the background to that the promoters wrote to the IEBC. The IEBC wrote back to the promoters, telling them that if you want to, the question that, rather, the letter that came from the promoters was, please help us understand the format in which you'd want to receive the signatures. The IEBC wrote back saying, thank you for your letter. If you want to give us the signatures, please present them in this format because this is what speaks to our infrastructure. My lords and my ladies, this perhaps will be the opportune moment to look at the template that was then created or shared by the IEBC. I don't know whether the court assistants would be in a position to help us get that, or if it will take time, I could quickly just make a quick reference.
Just refer to it. Just tell us the volume.
Thank you very much, madam.
Yeah.
Now, the document is found, like I said, at page 1100 of volume 2 of the appellant's, first appellant's record of appeal. It has details, my lords, which run almost one for one to the details that are set out in Form A. That is, we have the name, we have the serialization, we have the name, we have the ID and passport number, county constituency, county assembly ward, polling stations, mobile number, email address, signature, or thumbprint. My lords and my ladies, this then was the beginning of the question of verification. How did the IEBC then use this? My lords and my ladies, these details were then given, they were supposed to be presented in bound, serialized, and paginated booklets, both in hard and soft copies for purposes of accountability. When this information was availed to the IEBC, what they did is to then deploy their data entry clerk, and which was a big operation of perhaps more than 100 people. These, my lords, appear in the affidavits of Michael Goa, which have been set out at paragraph 4 of our submissions. They state, my lords and my ladies, that in the course of then re-entering that data, they omitted names which did not have signatures. They omitted names which did not have either passport or ID numbers. They also omitted names which had been duplicated. My lords and my ladies, this is because if you, for instance, allow a name that does not have a signature, then you'll be running afoul of the form for application of registration. The same goes to the details, and that's why it was important to set out that detail. My lords and my ladies, armed with now what they called the clean data, the Independent Electoral and Boundaries Commission took those names and ran the names through the register of voters in their custody. That is done through a software because of the numbers that they have. My lords and my ladies, that is so that then you can be able to compare that the details that you have, both biometric and in Form A, match the details that you have in the register of voters. My lords and my ladies, that was an important process because if you gave that detail then, or any name that appeared there, you gave it to an investigations officer, they'll trace that person back up to their village. That is just how interrelated all these issues are, so that if there was an issue to be confirmed, it would be very easy to relate it to the specific person. But more importantly, what does the IEBC do as the last step in the verification? They say that now that we have this detail, let us publish these details in our website and invite Kenyans to take time to run through these details so that they tell us if there is a single individual who would be saying that my name found its way into that register without my consent, then that would be the opportunity. That detail was sent, the publication was made, and the address of the CEO of a commission given. My lords and my ladies, at the time we were making submissions before the learned judges in the Superior Court, there wasn't a single person who had come forth saying that their name was irregularly or without their consent included in that register of voters. My lords, my ladies, let's pause there for
On what page is the notice? On what page is the notice to the public?
My lord, just I'll get back to that. Just allow me to get my assistant to help me trace that page. I'll get back to it. But I wanted to make the point, my lords and my ladies, that when Kenyans have become of age, just about 2 weeks ago, my lords and my ladies, the registrar of political parties did share details about political party membership in this country. It didn't take 2 days on their website for the media, social media, to be awash, to be active with people saying, I found myself registered as a member of this party, yet I'm not a member of that party. And that was just a period of 2 days. Within 3 days, my lords and my ladies, the data commissioner came out saying, we have seen the concerns that have been raised, and I have received more than 400 complaints. My lords and my ladies, I'm using this just to help us understand that it was effective, and perhaps also add that it is one of the ways that is used the world over. My lords and my ladies, let me then go into, now that I've said that, demonstrating why I think the learned judges of the Superior Court missed the point in relation to this question. I take us back, my lords and my ladies, to paragraph 733 of the decision. The learned judges of the Superior Court, my lords and my ladies, at that paragraph, frame a question to help them understand what the meaning of Article 257(4) is supposed to be. They say the question is whether the IEBC's role includes verification of signatures or whether the role only ends at the proverbial bean counting, a mere technocratic ascertainment that a popular initiative has delivered 1 million voters. My lords and my ladies, permit me to stop there for one moment to just unpack it the way we understood it. In our humble and respectful view to the learned judges of the Superior Court, we think that decision, that question was in itself not objective. Not objective for the simple reason that it is conclusive at the inception. Secondly, that question is inconsistent with the text of Article 257(4). Why do I say inconsistent? Because you see, the learned judges have already taken the position that they want to make an inquiry as to whether the IEBC's role includes verification of signatures, while the Constitution talks about verification of the initiative. My lords and my ladies, our other concern is that the learned judges of the Superior Court frame this question without looking at what the IEBC did. And my lords and my ladies, I invite you to look at this. Is dealt with from paragraph 720 to paragraph 765 of the judgment. They don't make reference at all to what the IEBC did. Secondly, and this goes into supporting what learned senior counsel Mr. Tiende said earlier, that they didn't also look at the text. The entire of that part, paragraph 720 to 765, does not make reference at all to the text of Article 257(4). What happens, my lords, after that? At paragraph 734 of a decision, the learned judges of the Superior Court say that in order to answer this question, we go to the affidavit of Dennis Waweru sworn on the 5th of February 2021. This affidavit is sworn on behalf of the BBI National Secretariat, one of the respondents in this petition. What do we have to say about this, my lords? We say that after framing a question which in our view was not objective, they went to a wrong place to look for an answer again to the wrong question that had been framed. Why do we say a wrong place? Let's start from asking ourselves, who is Dennis Waweru in the context of these proceedings? My lords and my ladies, it turns out that Dennis Waweru, from whose affidavit the learned judges of the Superior Court went to seek an answer, had filed an application for joinder in a petition in Mombasa. That is petition E01 of 2020, the Muhuri petition. My lords and my ladies, the reason why we think that is important is in an application for joinder, the test is fundamentally different from a test that one would be looking at when they're trying to understand the meaning of an article from the Constitution, specifically if that application is not made within the context of that application. My lords and my ladies, this affidavit is to be found at pages 3110 to 3121 of volume 7 of a BBI's record of appeal. That is the record that learned senior counsel Otende Amolo was looking at. So, my lords, it is our submission before you that if the learned judges had wanted to get the proper context of this particular affidavit, the first port of call, at the very worst, should have been to the actor, that is the IEBC. My lords, in that affidavit of Dennis Waweru, the learned judges...
Sorry, before you go to the affidavit of Dennis Waweru.
Yes, my lord.
What had the IEBC said about that position? Was there a specific affidavit to do with the construction of Article 257(4)?
Yes, my lord. We have in our submissions referred you at paragraph 4 to the various affidavits, because they were filed in several petitions, the various affidavits of Michael Goa, and we have even stated the specific pages. So when you get a moment, you'll probably get, that is a place to look at to get them. And even the unpacking is at page 41 of our submissions.
Counsel.
Yes, my lord.
It might be nice at this point,
yes, my lord,
for you to please address paragraph 737 of the judgment of the learned judges. First of all, if you look at 735, Council.
Yes.
735, you will notice they actually do talk about Article 257.4, which you say they make no mention of, but goes directly to 737. That is the report of your own client.
Yes.
As to what verification means.
Yes, my lord.
Yeah, if you could please address us on that.
Thank you very much, my lord. My lords, the learned judges of the Superior Court get this attachment, which they are now making reference to at paragraph 737 from the affidavit of Dennis Waweru. That attachment is a letter from the Independent Electoral and Boundaries Commission in relation to the Okoa Kenya Amendment, Constitutional Amendment Initiative in 2016. My lords and my ladies, that one of the two things that we'll say about that is that that letter or that the findings that then the learned judges relied on in giving meaning to Article 257.4 were then applied out of context. Why do I say out of context? Because what the commission then said they did in that letter are equal, perhaps the same, almost word for word, with what we say in the affidavits of Michael Goa.
Council,
the
please.
difference is...
Council, please.
Yes, my lord.
Just be direct. It's easier to just help us.
Yes, my lord.
The words in 737...
Yes, my lord.
You do not disown...
We do not disown
that report.
Yes, my lord.
You don't disown it. That is your client's... Those are your client's words with regard to Okoa, Kenya.
Yes, my lord.
Now, can you please tell us, help us, to understand what your client said verification meant?
So, my lords, two things that I would quickly want to say in relation to that. One, that in relation to Okoa, Kenya, we must then understand first that it didn't even get to the specific area around sending the signatures to the public because they didn't meet the 1 million threshold. But now directly to your question, my lords and my lady, at paragraph 33 of that report, the then chairman of the Independent Electoral and Boundaries Commission says that had they gotten to that threshold, then they would have gone to the next stage, which is what I've spoken to, which is now the publication. We didn't get there, my lord.
Do you have a problem telling us what your client said about what verification means? Do you have a problem with that?
My lord,
it's a very easy question. Please, what did they say?
My lords, I understand you to say, in that particular document, my lords and my ladies, the chairman of the commission in his findings said that verification includes verification of the signatures.
In fact,
yes.
What you say is that after reviewing practices in other jurisdictions,
yes,
it was clear that a person mandated to verify signatures must satisfy herself or himself that the said signatures belong to the persons whose names appear against them.
Yes, my lord.
My question is, did that happen in this case?
Yes, my lord. It did happen.
Your client was able to satisfy itself that the signatures belonged to the persons against whose names they appear?
Yes, my lord.
Okay, thank you.
Thank you very much, my lord.
Please carry on.
Thank you very much, my lord. So, I would want to end that point by saying that because the learned judges of the Superior Court looked at irrelevant factors, meaning the affidavit of Dennis Waweru out of context, which then would have led them to losing the context or the manner in which this should have been applied, and failing to take into consideration relevant factors, which in our view is the explanation in the context of what the IEBC had given, they then reached a conclusion that was at variance with the Constitution. My lords and my ladies, I will want to then quickly move. Let me end that argument by saying this. If for one moment we were to say that verification or authentication is to be given the meaning that the learned judges would appear to have suggested that it be given, is it possible or practical, my lords and my ladies, to have a forensic audit of the signatures of at least these 1 million people, my lords and my ladies, I would start from the premise that one, we don't have a database of signatures in this country. I would also want to add...
Council, you just said they did, that they confirmed.
Yes, all I'm talking about, my lords and my lady, is from the judgment, there appears to be an indication that there should be a forensic.
Okay.
Yes, that is the difference. So, my lords and my ladies, I'm saying, if we went that direction of a forensic evaluation of the signatures, it would be a difficult assignment, it would be an impossible task. Speaking as a practicing lawyer, my lords and my ladies, whenever I'm faced with a document which requires verification, you send that document, my lords and my ladies, to the DCI to help you authenticate the signature or the handwriting. The shortest time it takes is a month. That is one document. If we have 3.4 million signatures that we received, would it be possible to give that sort of a meaning to that article? I rest it at that, my lords and my lady. I see my time is quickly running. Permit me to go to the second area of my presentation, which is in relation to the question of the separate registration of voters for purposes of a referendum. My lords and my ladies.
Sorry, I don't know that you're moving away from the area of the verification.
Yes, I'm moving to the next.
From reading of the judgment,
yes,
it seems like the case for the IBC was that because there wasn't a legal framework for verification under Article 272, the Article 257.4.
Yes, my lord.
Then the IBC fashioned some administrative procedures.
Yes, my lord.
And your argument before the Superior Court was that those administrative procedures met the threshold of the Constitution.
Yes, my lord.
And we must recall what Senior Counsel Oraro submitted yesterday, that the provisions in respect to the referendum are in fact more exciting than that of a presidential election. Now, please comment, assuming that the administrative procedures in fact made constitutional muster.
Yes, my lord.
Do comment on paragraphs 761 and 762 of the judgment, and just let me read it because it's short. In addition, even if the administrative procedures had been valid, it is clear that the IBC did not comply with them. For instance, IBC published the list in the website on Thursday, 21st January 2021. Members of the public had up to Monday, 25th January 2021, to read the list and raise any issues. The judges then say that the administrative procedures provided for a 2-week period so that the registered voters could verify or make comments, but IBC only gave 5 days, including the weekend. First, is that a finding of the court factually accurate, that the period was shortened from 2-week period to 5 days?
My lord, thank you very much for that question. Two things that I want to say about that. One is that my learned friend, Mr. Kipkoge, will be addressing you after me in great detail about the legislative framework, the legal framework. But in relation to the specific question that you asked, that is on paragraph 761, one of the issues that we'll be addressing you on is that the administrative processes have been mischaracterized. They've been mischaracterized and elevated to a position where they would fall to be under the Statutory Instruments Act, which they are not. These are internal procedures. Why do we say the internal procedures? My lords and my ladies, when we, for instance, say that please delete the name of somebody who does not have an ID, it is because of the reading of the fact that that person is not a voter in relation to Form A, which had given. So that is why we relate it, and we say you don't need a law to tell you that once the Elections Act has defined a registered voter is somebody who has given you their ID number, then you don't get the ID number. You don't need another legislation to come and tell you, please now remove the legislation, because it fits under the rubric of Article 257(4) that a registered voter must be that person who has given those details. So the moment you fail to give any of those details, then you don't fit into that space. So it will be our case, and Mr. Kipogei will be addressing you on that later, that if we had understood those administrative processes to be internal processes, then we would not then create the obligation that the learned judges created about them. To answer the second part of the question in relation to the shortening of the period, my lords and my ladies, there is need to create some flexibility to the institutions that we have. We have the commission receiving or sending out a notice that we will be happy to receive a complaint from any Kenyan who would say that their name was not included in this, or rather, their name was included without their consent. My lord and my ladies, after 5 days, you've not received any. Must you wait for the 14 days? And I want to look at the converse of this. If we had gotten, my lords and my ladies, to a period of those 14 days, and names are still coming in, my lords and my ladies, will we say, no, ours is 14 days, anything that comes after this does not matter to us?
I asked the question because if you look at the framework on verification of the voter register,
yes,
it has a window which is known to all Kenyans and gives them sufficient time to do that. And I'm not saying that the procedures of the administrative procedures of IEBC are subsidiary legislation, but if having, and the IEBC has the experience of conducting referendum and the election and the competence. They thought about it, they said 14 weeks is a fair period. But then in their wisdom, they then choose to reduce the period to 5 days. That was...
Yes, my lord, and perhaps so that then we just look at it in proper context, even on that question, it would be equivalent to comparing two things that do not exactly fall for comparison for this reason. When we are looking at giving time to Kenyans out there to come and verify their details, say for a period of 30 days under the Elections Act, it is a statutory provision under Section 6 and 6A. What do those do, and why does it happen that way? It is because the register is our document as the IEBC. Once you've given us, you made the application and given us your details, we tell you, okay, now we've captured your details, but before we get to the elections, before we get to a referendum, please take time to go and verify your details from our document. The flip side or the difference would be the promoter is the person bringing you their document, saying this is our document. My lords and my ladies, I think there is a bit of a difference in relation to that question. My lords and my ladies, I'm seeing time is running quite a bit. Permit me to talk about the question of separate registration of voters for purposes of the referendum. My lords and my ladies, we draw your attention to paragraph 769 of a judgment of a superior court. If you permit me, I could very quickly read through it. That say, we begin by noting that every single day, citizens attain the voting age. These new citizens have a right to be registered as voters and to participate in the proposed referendum. There was no evidence placed before this court that the IEBC has been discharging this constitutional and statutory obligation to enable the citizens who have attained the voting age to register as voters. The IEBC also stated that the last time the voter register was revised, and I repeat, was revised, was just before the Kibra by-elections. This was a confirmation that it was not discharging its constitutional and statutory mandate to continuously register voters and review the register of voters. Because of that analogy, they then, at paragraph 9 of the declarations that they make, say that a declaration is hereby made that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum before the Independent Electoral and Boundaries Commission carries out nationwide voter registration exercise. My lords and my ladies, permit me to also relate that to the submissions made by the respondents, both in the court below and this court. I would want to again pick on the submissions filed by Mr. Morara Omoke, the 76th petitioner. Mr. Morara Omoke, in the submissions filed before you, at paragraph 117, says, we invite this honorable court to take judicial notice of the fact that the predominantly youthful dynamic of the Kenyan population is such that hundreds of thousands of citizens become eligible to be registered as voters every year. Since it is common ground that the IEBC last updated, again underline, last updated the register of voters between February 2017 and March 2017, the 76th respondents' apprehension about the disenfranchisement of billions of voters in the intended referendum is well-founded. My lords and my ladies, what do I have to say about this? I say that both the learned judges of a superior court as well as the respondents misconstrued the meaning of the various words that are used interchangeably within the electoral platform. Example, when the learned judges say that the register of voters was last revised in relation to the Kibra by-elections, what exactly, why do we say they were wrong? We say they were wrong because the context in which they are using the word revised is to mean continuous registration of voters, and which they then say that the IEBC has failed on. My lords and my ladies, the word revised used in the electoral sense has a specific meaning. To this, my lords and my lady, look at section 5 of the Elections Act. My lords and my ladies, section 5 of the Elections Act, almost in similar terms, provides for the regular and continuous registration of voters. It then provides for exceptions. The exceptions being that where you have a by-election, then the registration in relation to that, say, either county assembly ward or constituency will be stopped for a moment to facilitate that election. How does it facilitate that election? That at that point you close the register and again allow section 6 and 6A to fall into play so that the people who will be voting in relation to that area can come in to correct their details ahead of that particular exercise. The same thing goes for when you have a general election. The same thing goes under the exception at 5C for a referendum. That is not C but BA. It's numbered as BA. So the word revised then as used in that context is for purposes of enabling section 6 and 6A to kick in. And so when the learned judges of the Superior Court asked the question, and it was a question that came from the court because it wasn't an issue, Kibra came in as an example. That when did you last, at that point in time, the last by-elections that had just been held were the by-elections in Kibra. And so then learned counsel then appearing for the IEBC made the explanation that the last time we revised the register of voters was in relation to the elections in Kibra. So that is not to mean and should not be equivalent to saying that there was no continuous registration of voters. My lords and my ladies, again, the same mistake. It's a mistake again of terminology is used by Mr. Morara Omoke when he says it is common ground that the register of voters was last updated. The updating that we're talking about here is different. And my lords and my ladies, I would invite the court to look at the provisions of Article 88.4a, 88.4b. 88.4a, my lords and my ladies, if I could very quickly just so that we understand the distinction between these two processes, reads that the commission is responsible for, among other things, the continuous registration of voters, and B, the regular revision of the voters' roll. Continuous registration of voters carries on, and my lords and my ladies, the IEBC has 290 offices throughout the country which conduct this continuous registration of voters. Revision of the roll, on the other hand, is once you've mined details or data from the applicants who want to be enrolled as registered voters, you then periodically
take that data and upload it to have the register of voters. That is a continuous process. My lords and my ladies, the question that I would want to ask now that I'm there, why do we, in resolving that question, start by asking, why do the learned judges of a superior court start by asking for evidence from the IEBC? If the case was a case that was presented by the petitioners, the first port of call, my lords and my ladies, as we know it, is he who alleges must prove. There was an obligation on the part of the petitioners in the lower court to then discharge that burden. My lords and my ladies, you'll have a moment to look at the record. There wasn't a single drop of evidence that was given in relation to the fact of there being no continuous registration of voters.
And what did the IBC say about that issue?
The question about registration of voters?
Yes.
My lords and my ladies, we have the replying affidavit of one Michael Goa, where Michael Goa states categorically that the registration of voters has been a continuous and ongoing process.
Thank you. Let me just understand. Whenever we have an election,
yes, ma'am,
beyond the continuous voter registration, which you say IEBC has been conducting,
yes,
with an election looming, is there something more that your client does in preparation for the election?
Yes, my lord. Permit me to address you on that.
Yes, and I imagine that is that they actually carry out a nationwide voter registration. Is that correct?
Not quite.
What do they do?
Continuous voter registration carries on. What they do is, again, to use their internal flexibility. They say, we need to now go out and encourage Kenyans to vote, or rather to register for purposes of election. That is what has been dubbed mass registration of voters.
Exactly, mass registration of voters.
Yes, madam.
And that is to ensure that when the people vote, you can have as much a representation of the people, registered voters as possible.
Yes, madam.
Would that wise approach also be one that the IBC would do with regard to an important question like a referendum on the Constitution?
Oh yes, my lord, that's true. The only thing that we then need to ask ourselves is, at what point does the IBC make that decision? We say that decision, my lord, can only come when the IBC is seized of the referendum. As we speak, the IBC is not seized of any referendum.
Thank you. So now, if you look at the declaration that you have a problem with, what did he say about that, about registration?
A declaration is hereby made that the Constitution of Kenya amendment...
What page, sorry, what page of the...
That is, I think, at page 312, that's the last declaration, number 9. A declaration is hereby made that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum before the Independent Electoral and Boundaries Commission carries out nationwide voter registration exercise.
Is that the same as mass, the mass thing you're talking about?
Not quite. Nationwide, it's always an ongoing process, because even now there's a nationwide registration of voters.
So do you have a problem with that declaration as it stands, that before you can have the referendum, because they're saying before the referendum, before you can have the referendum, there should be a nationwide voter registration. Is that a problem?
Yes, my lord. It is a problem in this sense. It first presupposes, because it comes from a concern that was raised by the petitioners, that there is no voter registration going on. And my lord, it's not just about registration.
But if you actually are doing it, it means they are declaring that which is already happening. Why do you have a quarrel?
My lord, perhaps context is also important for this. Before the IEBC engages in any of these activities, what do? They get data from other institutions. National Registration Bureau, they ask them, how many people have you registered, for instance, in the last 6 months? So on account of those sort of statistics, they make informed decisions that, oh, we think that there's been maybe about 500,000 more Kenyans that have been registered. Let's have a drive. Let's encourage. The more important question, though, is why don't we let the IBC be the ones to make that decision? Why do we want to look like we're getting into their position and telling them, we know you IBC, you may not register us after all. We want to have an order just in case. Why can't we allow them to do? In any case, my lord, when properly seized of the referendum, when the opportunity eventually comes, the IEBC will look at this data and they'll say, we think perhaps it will be their decision. I'm not preempting that we now need to run mass voter registration. All that I'm saying is we need to give them that flexibility to make it their decision because of their independence. Thanks, my lord.
So Mr. Gumbo, what I was asking is this, because you referred us to paragraph 769, yes, where the learned judges say that IEBC was not discharged its constitutional and statutory obligation to enable citizens, to do continual registration. You referred us to the paragraph 117 of Mr. Omorara Omoke.
Yes, my lord.
Now, to enable the court reach an informed conclusion or finding as to whether the learned judges were right in the words they put in page 769, can you please show me or show us the affidavit of Michael Goa where you said the contrary, so that we are able to place it in its context?
My lords, this is volume 5 of the record of appeal.
So we will find it at volume
5.
Volume 5.
Page 2193.
2193.
At paragraph 10.
So that answers, in your view, the issue raised by the learned judges at paragraph 767, 769.
Yes, my lord.
Thank you.
Thank you very much, my lord. And more importantly, my lord, like I said, before the learned judges pose that question, the primary obligation on the part of the petitioners would have been to discharge that burden. My lords, would be looking at a situation where somebody says, and this I think is what learned senior counsel Professor Githu Muigai was alluding to, we would want a situation where somebody says, I am a Kenyan. I approached the IEBC to register as a voter and I was denied that opportunity, or that there was a potential threat of me being denied that opportunity. In the absence of that, my lord, we cannot rely on what Mr. Morara Omoke says. He is apprehensive. An apprehension, my lords and my ladies, is not evidence. My lords and my ladies, perhaps now...
Are you watching your time?
Yes, my lord, but I'm also praying that for the interventions, my lords and my ladies, perhaps there's equal attention to the time that runs off our plate.
Yeah, just before you move on.
Yes.
Now, you have said the onus was on Mr. Omarara to prove the allegation. And at the same time, you are telling us this is specialized information that your client insists of. Don't you think that the farthest Mr. Omarara could go is to raise that issue? And then what for your client is simply to come forward and say, yes, you have raised this. As a Kenyan citizen, you are entitled to it. And here is what I have. What you are asking for is already in place. And I think that is what the judges were interrogating at the paragraph 769, what the president has brought to your attention.
Yes, my lady.
Yeah.
May I respond?
Please do.
So, my lady, it is okay to make such an inquiry, but must such an inquiry be made for the first instance in a court? That is the concern. Why don't you, as a responsible Kenyan, come in and say, wait, we think we may be running into an election. What are you people doing about this election? Is there a continuous registration of voters? Please get me a document to see that there's continuous registration of voters or there's none. It is not, in our view, okay to make a first port call, which reminds me of what I learned in the laws about injunction, something called quia timet injunction. You just say, Timeo, I fear. My lords, I think there's a greater obligation. There's a greater obligation on anybody who wants to confirm, and that, my lord, again, is information that is available out there. Every so often, And perhaps I'll just make reference to the affidavit of Michael Goa, again filed on the 25th of June 2021 at paragraph, that is, at paragraph 6, my lords and my ladies, attaching a gazette notice. My lords and my ladies, that gazette notice does one thing. Every so often, the Independent Electoral and Boundaries Commission, as a way of communicating to Kenyans, says that we have up to now gotten this number of registered voters. We have shared one of those gazette notices, so that then it is just confirmed, because it is a legal provision that it is that, my lords and my ladies, there is continuous registration of voters. My lords and my ladies, perhaps I would move then to the next part of my presentation on the question of public participation. Sorry, my lord. Thank you very much, my lord. So on the question of public participation, specifically as to whether there is an obligation on the IEBC under Article 2574 to confirm that a promoter...
Mr. Goa, please permit me. I'm so sorry about this.
Yes.
You made reference to this gazette notice.
Yes.
Which is attached to Mr. Goa's affidavit.
Yes, madam.
I just confirm that this is gazette notice number 2934 of 16 September 2020.
Yeah.
Right?
Yes, my lord.
Now look at it.
Yes, my lord.
It says you are certifying the completion of the revision of the register of voters as at what date?
This is as at 31st December 2019.
2019.
Yes, madam.
This is something that Mr. Goa filed here before us 2 days ago. Am I right?
Yes.
So you get an opportunity to indicate what you're doing with regard to continuous nationwide registration, and what you brought before us is an indication of registration as at 31st December 2019.
Yes, my lord.
Okay.
And permit me to explain why.
No, I just confirmed the date.
Yes, my lord, but
Okay.
it is important that I contextualize it.
All right.
The obligation, my lords and my ladies, that is done periodically. So that, again, towards the end of this year, there'll be a similar gazette notice issued. It doesn't mean that there's no registration going on. It's only that it can't be issued weekly. You issue it maybe after 6 months, you issue it after 1 year.
Was there one indicating registration as at the end of 2020?
My lords, I maybe would want to just confirm that from the clients.
All right, thank you.
Yes, but my lord, the position, as I indicated, what was the evidence that was presented by the other side? Why do we want to shift the burden to say we allege, prove? We must start from somewhere for sure.
Thank you.
Most obliged, my lord. Then on the question of public participation, we look at paragraph 577. The learned judges of the Superior Court say that additionally, the IEBC was under an obligation to ensure that the BBI steering committee had complied with the requirements of public participation before determining it had met the constitutional requirements for transmittal to the county assemblies. What do we have to say about this, my lords and my ladies? Simple. Article 257(4) reads, shall verify that the initiative is supported by at least 1 million registered voters. Where do we get this obligation and impose it on the IEBC from that article? My lords and my ladies, I have tried to interrogate the submissions that have been presented, even by the respondents, on that question of public participation. The closest I've come to is submissions filed by a learned friend, Mr. Harvey, which says that that obligation is to be found in the writings of John Locke, Baron de Montesquieu, and Professor Ben Nabweze. This is found at paragraphs 36 and 38 of the submissions that have been filed. My lords and my ladies, I want to pose the question. Would it be open for the IEBC to reject a bill together with more than 1 million signatures presented on the question of public participation, would they object without attracting or fomenting a cause of action against them as imposing a condition that the Constitution does not contemplate? My lords and my ladies, it should not be taken that the IEBC does not appreciate public participation. The question of public participation is so important under the heart of IEBC. The only thing that we are saying is that that public participation must be context specific. In relation to Article 257.4, my lords and my ladies, that obligation does not lie with the IEBC. We've seen, if we read the entire spectrum of Article 257, we have obligations to the county assemblies, the parliament, and the grand extravaganza itself if we ever get to the referendum. That is the ultimate public participation. IEBC would be ill-equipped to get to a point of saying that we are rejecting your initiative because you've not given us minutes of meetings that you had or any other demonstration of public participation, because the Constitution at that point in time does not impose the obligation on them. To the flip side, my lords and my ladies, that would be a very good ground for somebody to raise if at the end of the day or at the end of this process, somebody files an application under Section 80 to 88 of the Elections Act to file a referendum petition where somebody will be challenging the fact of there not having been sufficient public participation.
The learned judges were saying that IEBC was interpreting and applying the Constitution.
Yes, madam.
And therefore, the values espoused under Article 10 kicked in. What do you have to say about that?
Yes, my lord, they kick in. But at what point, who has the tools to measure that? At that point in time, the requirement for purposes of confirming public participation is a requirement that if you read, and this is about holistic reading of the Constitution again, if that obligation to make that confirmation that there was public participation is reposed expressly in another institution, then it would be inappropriate for IEBC to tell somebody that before you come to me, present me with three things. Get me a bill, get me 1 million registered voters, and also get me evidence that you had public participation. My lords and my ladies, that is stretching the meaning of the text of Article 257.4.
And I think we've really had many interventions. But I understood, and maybe you could comment on this, I understood Senior Counsel Kambuni to say that in fact, at the point when someone, and I don't want to use the word initiator, which you have a problem with, someone initiates the process under 257.1 and collecting the 1 million votes, there is no need for public participation. That in fact, you can look for people who share the same view, friendly people, as long as you get the 1 million votes. And that the issue of public participation is at the point the bill is then presented to the county assemblies. So, I mean, you could connect that. I don't know whether you have a comment.
Yes, Article 257.1 is the one that then introduces that threshold. And my lords, the obligation under Article 257.1 is reposed in the promoters, so that if today we sat with your lordships, ladyships, as members of the legal fraternity, we say that we have looked at this constitution and we've specifically looked at Article 163.3a, the jurisdiction of the Supreme Court to make a determination on a presidential petition. And we think these 14 days are too short for that court to do that, to do justice to that matter. We need to expand or get that period expanded. What does that mean? It is a well-founded proposal. What does the Constitution expect? We may sit here, we may be 100 people. If you go to the IEBC today, you tell them, this proposal makes sense. You say, all right, it might make sense to you, but because this Constitution is a document that is shared by Kenyans, can we get at least 1 million of you who think the same way so that we can engage Kenyans? So essentially, it's more of a trigger. So that you say, we've gotten 1 million people who think that there's need to expand for the 14 days, please consider them. Then the other Kenyans will be asked, oh, there's a proposal to expand this period. We then open it up to a debate. We say the reason why we think there's need for this proposal, or rather for this amendment, is so that the court can have perhaps 30 days, so that there's not too much pressure on the court. It will now be upon the actors in that space, the various actors, to engage in public participation at that point in time. That is my understanding of that provision, my lord. My lord, my ladies, perhaps I would quickly then run to the last question about the referendum question. On this issue, my lords and my lady, paragraph 611 of the judgment, the learned judges of the Superior Court say, we have been asked to determine whether Article 257.10 requires all the specific required amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot. My lords and my ladies, the learned judges of the Superior Court then go on to make a finding, that is Declaration 18, that a declaration is hereby made that Article 257.10 of the Constitution requires all specific proposed amendments of the Constitution to be submitted as separate and distinct referendum questions to the people. My lords and my ladies, why do we, as the IEBC in particular, why are we aggrieved with that finding? One, I would want to ask the question, the learned judges of the Superior Court, they were invited. First principles, whenever you're invited to make a determination, you ask yourself, and this is the point that learned senior counsel Professor Githu Muigai was making, you must ask yourself whether you have the jurisdiction to make that determination. It is not just a question of saying a question was presented to us. Satisfy yourself. My lords and my ladies, we say that because in the absence of a controversy, you present such a question to the IEBC, then you are at best inviting them to exercise advisory jurisdiction, which they do not have. I then ask myself the question related to that. What was the controversy that was presented for the determination of the learned judges? My lords and my ladies, at the second paragraph after the learned judges, I think paragraph 612, the learned judges find a report. They say that the petitioners cited the final report of the Independent Commission on Referendums on this question from the University College of London. My lords and my ladies, how is this report to form a controversy that is being discussed in a court of law in Kenya? Let me leave that at that and say, my lords and my ladies, Section 49 of the Elections Act reposes the obligation to make a determination on a question touching on the referendum on the IEBC. In particular, 49.2 says, where an issue to be decided in a referendum has been referred to the commissioner under subsection 1, the commission shall frame the question or questions to be determined during the referendum. Now, with that as a background, I submitted earlier, the IEBC is yet to be seized of this referendum. They can only and will only be seized of this referendum if under Article 256(5)(a), His Excellency the President sends or triggers that jurisdiction. So before that arises, it is then our humble submission that it is premature to expect the IEBC to have engaged in that question. My lords and my ladies, it is our submission that that issue was not ripe for determination before the learned judges of the Superior Court. My lords and my ladies, again, it is important to note, and this is a point that learned senior counsel Professor Githu made very well, the IEBC is an independent institution. They cannot be, and we cannot have a situation where what they're supposed to be doing is being discussed away from them and a direction given to them that you shall, at the point of dealing with the referendum question, do A, B, C, and D. My lords and my ladies, This, in our view, is an inappropriate application of the Constitution. And my lords and my ladies, I am not alone in saying that. A member of, a honorable member of the bench, Justice Fred Ochieng, in a case that we've referred to time and again throughout this decision, that is the decision in Titus Alila, and it's cited as one of the authorities that appears at page 230 of our bundle and digest of authorities, when faced with a similar question on the issue of referendum, had the following to say. At paragraph 57, Justice Ochieng says, Section 49 of the Elections Act gives to the IEBC the mandate to frame the question or questions to be determined through a referendum. At paragraph 59, the learned judge says, this court cannot purport to give the IEBC directions on exactly how to carry out its responsibility in that respect. The last paragraph, in a bold statement, it says, if the court were to give generalized directions to the IEBC when it had not been shown that the commission had started from a path not established by law, that would constitute a blatant interference by the judiciary in the constitutional mandate of an independent commission. My lords and my ladies, that decision was presented before the learned judges of the Superior Court. We have seen the declaration that they made. We leave it to you, my lords and my ladies, to make a determination. On my feet, my lords and my lady, I would want to make a plea that on that question, and it reminds me or takes me back to the to the question that Justice Gatemu Kairu asked. When faced with such a situation, would it not be right to have a setting where there is a harmonious way of facilitating institutions to work with what I would call clear directions from courts in terms of court judgments? My lords and my ladies, what am I saying? I'm saying it places independent institutions in very awkward positions when today there is a judgment that could come from Judge X in a place Y, tomorrow another decision touching on the same issue, constitutional interpretation, again from another judge. It leads to a situation where we will be forum shopping. My lords and my ladies, that is not the sort of practice that we want. In fact, as a practitioner of law, my lords and my ladies, I've been put in a place where sometimes it is difficult to even advise a client. You advise, you give a written opinion, but you must timestamp it. Why? Because if you don't timestamp it and issue a disclaimer that my opinion is valid up to the time I'm signing this decision, another contrary decision will come from somewhere. And my lords and my ladies, you'd be accused of having misled an institution. Our proposal, my lords and my ladies, is that when dealing with these sort of issues, particularly interpretation of a question of public law, it could be a constitutional interpretation. My lords, my ladies, you may want to give guidance in how then the court below you, the learned judges of the Superior Court, can apply or exercise their jurisdiction without creating hardship to the institutions that depend on them for guidance and interpretation. An example would be the Lady Justice Okwanyi says that IBC, you have jurisdiction. Please you have quorum, carry on with what you're doing. So they then go on to make arrangements, do this, do the other in relation to their institution. Shortly thereafter, they told, wait a minute, whatever you did in the hope that you had jurisdiction is actually null and void. What does that do to institutions that then are expected to apply the law? It then places them in a position where the man in Kangemi bus would start doubting the ability of these institutions to work the way they should work. So it is a really important question to ask. Let us have, my lords and my ladies, a Titus Alela moment. Let's have a guidance on this very pertinent issue. My lords and my ladies, with that, I think I'm only left with 15 minutes. Permit me to allow my learned friend, Mr. Moses Kipkogei, to address you on the other matters. I'm most obliged for your patience. Thank you.
Mr. Kipkogei, it looks like you have only 15 minutes.
My Lord and my ladies.
Just state your name for record, and you may want to lift up, to raise the microphone.
My name is Moses Kipkogei. I join Attorney General Emeritus, Professor Muigai, and Mr. Gumbo in appearing for the IEBC. I will try my best in the remaining time.
Are you able to adjust the microphone so that it is kind of...
Yes. It's an issue to do with height, my Lord. I should perhaps have had a longer podium. My Lord, I will address my Lord on 3 elements which arise from the decision of the Superior Court in relation to the declaratory reliefs which were granted by the court. And that relates, my Lord, to declaration number 11, declaration number 12, and declaration number 17, which are contained at pages 7167 and 7168 of our bundle of our record of appeal. My Lord, those 3 declarations relate to the legal regime applicable for purposes of conducting a referendum and the finding in relation to the administrative guidelines which were issued by the IEBC to govern the process. I note, my Lord, that Malanet seniors who have addressed you ahead of me have touched on those, and I will try to touch on areas which they did not touch on. But before I do so, my Lord, allow me to address you on just one aspect which arose from Mr. Gumbo's submissions in relation to the interpretation to be accorded to Article 257, sub-Article 4. My Lord, the learned judges of the Superior Court expended quite some considerable effort in unpacking the phrase verification of signatures. My Lord, that phrase does not exist anywhere in the Constitution. What is in the Constitution, my Lord, is a phrase which reads as follows: verification, quote unquote, verification that the initiative is supported, and it continues. And it ends with voters. That was important, my Lord, to highlight because it is direct, it directly affects the process which was put in place by the IEBC, including the administrative guidelines which were published, which were issued by the Commission. My Lord, declaration number 11, my Lord, in that declaration, the Superior Court states as follows, that a declaration is made that at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor a legal framework to govern the conduct of referenda. They repeat in somewhat similar language in declaration number 12. My Lord, allow me to address you on the last sentence or the last phrase of that declaration, nor a legal framework to govern the conduct of a referendum. My Lord, the Elections Act, in its long title, states as follows: that it's an act of Parliament to provide for the conduct of elections to the office of the President, the National Assembly, the Senate, the County Governor, the County Assembly, and to provide for the conduct of referenda. My Lord, we submit that the declaration by the Superior Court that there was no law governing the conduct of referenda was erroneous and without basis, because there is an act of Parliament which declares itself in its long title that it governs referenda, and it is the Elections Act. When you go through the Elections Act, my Lord, you will note that in relation to the Register of Voters, the Register of Voters applies to both elections to elective positions and referenda. In relation to accreditation of observers, Section 40, it applies, my Lord. There is a whole part 5 of the Elections Act, which is dedicated to referenda. There is a whole chapter dedicated to dispute resolution for referendum processes, running from Section 88, my Lord, to Section 103 of the Elections Act. The Electoral Code of Conduct, which is a schedule to the Elections Act, applies not only to elections, but also to referenda. The word referendum has been used in the Elections Act 167 times. My Lord, Election Offences Act applies not only to elections, but also to offences committed in the course of referenda. The Election Campaign Financing Act, my Lord, also applies to referenda. How then did we end up with a finding by the Superior Court that there is no law governing the conduct of referenda in Kenya? My Lord, that was an erroneous finding, and we will be asking you to set aside that declaration without much ado. My Lord, if you look at the election general regulations on the conduct of elections, they apply to referenda as well, including the statutory forms, which are an annex to the elections general regulations. In fact, one of the forms, my Lord, is a sample ballot paper for the referendum, Form 30, which is provided for in the elections general regulations. My Lord, when you look at the elections registration of voters regulations, you will find statutory forms, like for instance, Form J, which is a form for registration of voters in the diaspora. That particular form applies to voters who wish to vote in the diaspora and contains an express limitation that those voters who wish to participate are only limited to participate in referenda and presidential elections. My Lord, consequently, it is an erroneous finding to make that there is, that there is no law governing referendum processes. It would have, perhaps the court would have limited its findings to collection, presentation, and verification of signatures. But they went ahead to say that there is no law with legal framework governing the conduct of referenda. My Lord, I want on those three elements, collection of endorsement signatures, presentation and verification of signatures, my Lord, to associate myself with submissions of counsel who have submitted ahead of me and submit, my Lord, that Article 2, 57 sub-article 4 is self-executing in that regard. It says what it says. It permits no laborious interpretation. It directs promoters of the initiative to submit the bill with the accompanying signatures to the Commission, and the Commission shall verify that that initiative, it is the initiative which is being verified, is supported by 1 million registered voters. There is no requirement for a forensic analysis of signatures. It is a confirmation that the persons who are said to support the initiative do support the initiative. And it takes many forms, my lord, and we've elaborated in our submissions the mechanisms which are available and which have been tested worldwide for the verification of signatures to support an initiative. It is not, as Mr. Gumba has put it, a process where investigators have to be called in to check whether the signature belongs to that particular person in the sense of an investigation under like a criminal investigation. My lord, allow me to spare my remaining 5 minutes to address you on the administrative procedures which were published by the Commission. My lord, under Regulation 100 of the Elections General Regulations, the Commission has been donated power by Parliament to publish guidelines in the Gazette. And when the Commission is minded, as an EMB, to publish guidelines, they do so. With respect to the guidelines which I alluded to in the judgment of the Superior Court, the Commission did not publish. It was not because for want of power or lapse in its processes that they did not publish. It was deliberate, because they are internal rules. They are meant for use by itself. You will have occasion, my lord, I do not have time to take you through those regulations, but you will notice, my lord, that it is in the nature of a standard operating procedure issued by commissioners to its secretariat. How it landed in this court and became a subject of challenge, my lord, is, you will notice from the record, my lord, that a request was made by the 82nd respondent, Muhuri. And they asked, do you have any guidelines which you use to verify signatures? And there was a response from the Commission. Yeah, oh yes, we have regulations, we have guidelines, our internal guidelines. They took those guidelines, together with a letter from the Acting Commission Secretary of the IEBC, and challenged it in court. That is how those guidelines have landed before you. But otherwise, they would have been at anniversary towers, not subject of challenge. They are internal to the Commission. They are manuals, internal manuals for the Commission, standard operating procedures. They have not acquired and were never intended to acquire the status of a statutory instrument within the meaning of the Statutory Instruments Act or Cap 2, Interpretation and General Provisions Act, and consequently, they should not have attracted the order which was, the declaration which was issued under Declaration number 17 of the Superior Court's declaratory reliefs. And consequently, my lord, we will ask you to set aside those declarations. My lord, allow me to spare the last minute to clarify one issue which was addressed by Attorney General Emeritus with respect to the existence of unamendable clauses and whether the High Court made a finding to that effect. I'll just refer you to the appropriate paragraph in the judgment of the Superior Court. At paragraph 681F, where the court states in no uncertain terms that amendments to Article 89 are unamendable. My Lord Justice Kiage had posed a question to Attorney General Emeritus whether the Superior Court made such a finding. My Lord, that finding does exist, where the Superior Court stated that amendments to Article 89 are unamendable. That would be all, my Lord. I will donate the last 30 seconds to the court. We ask you... I will ask my lords to allow our appeal, set aside the judgment of the Superior Court.
Thank you for your generosity, Counsel.
Thank you, my lord.
Thank you. Now, on that happy note of a donation of time to the court, we have, I think, one appellant remaining only. Is that so, Senior Counsel Mr. Wetonyi?
Yes.
And you said you would take 1 hour because you donated 1 hour?
Just 1 hour, perhaps with a bit of concession from the court, a few more minutes.
So you have like 25 or 20, about 20 minutes or so. You can start before we rise it. Okay. All right. We'll break now. We'll break now. Okay. The view is that we break now because it is about 8 minutes past 1.
Yes.
And then we need to start promptly at 1 hour after this time that we are joining. In the morning we had an unusual occurrence where council were late for quite some time. I think we need to manage our time appropriately. So we are now going to adjourn at 10 minutes past 1. I suggest we reconvene exactly at 10 minutes past 2.
I was going, my lord, to request your lordships to allow us a little bit longer time. This is lunch hour. We come at 2:30. If that is acceptable.
The lunch hour, we agreed and we were starting that it will be 1 hour.
Yeah.
So I respectfully suggest that we still take 1 hour because we have many parties to listen to. So let's come after 1 hour.